A longtime Hazel Crest school board member's decades-old felony conviction for possession of a stolen vehicle does not disqualify him from holding office on a board of education, an appeals court has ruled. The Illinois Appellate Court May 11 affirmed a lower court's decision that Hazel Crest School Board President Dean Barnett had not committed an infamous crime, as defined by state law, and could therefore serve on a local school board. "I have welcomed resolution to this matter since its inception," Barnett said in a statement expressing his satisfaction with the appellate decision. "It's my hope that the case law created through my decision will serve as motivation to some young person who believes that they will never be able to live their best life as a result of them having had used poor judgment, sick." At some point, Barnett, a local business owner who voters overwhelmingly supported for a fifth term last year, was sentenced to 2 years probation following his felony conviction for receipt, possession and sale of a stolen vehicle in 1993, when he was 17. He said in a statement that the conviction had haunted him ever since, but that the adversity had pushed him to pursue a life of public service. Shortly after Barnett's re-election last year, a Hazel Crest parent who had run unsuccessfully against him challenged his ability to serve, arguing that his felony disqualified him from holding office. While a felony conviction does not automatically disqualify an individual from serving on a school board in Illinois, courts have held that felons convicted of infamous crimes were ineligible to hold school board seats. The list of 18 offenses, from bribery and burglary to murder and rape, that Illinois Criminal Code initially defined as infamous, was repealed in 1986. In recent years, an infamous crime has been interpreted more broadly, as anything inconsistent with commonly accepted principles of honesty and decency, according to Max Solomon, the attorney who challenged Barnett's eligibility to hold office. Solomon argued that, under the broader definition, Barnett had committed an infamous crime, but the appellate court found otherwise. It opined that the original definition of an infamous crime remains applicable today, despite its prior appeal. Since Barnett's crime, possession of a stolen motor vehicle, was not one of the offenses delineated on the list, it was not an infamous crime. The court found the only infamous crime even remotely related to Barnett's conviction is theft, the appellate opinion states. Barnett was not convicted of a theft. Rather, he was convicted of the less severe crime of possessing stolen property. Feds seek records from Hazel Crest District on board president, company that built 2 schools. Therefore, the infamous crime provision does not disqualify Barnett from holding office as a member of the Board of Education. Solomon did not return requests for comment, so it wasn't immediately clear whether he intended to appeal the ruling to the Illinois Supreme Court. Bert Adelson, an attorney who specializes in local government and election law but was not involved in Barnett's case, said it represented the first time, to his knowledge, that an Illinois appellate court had weighed in on the eligibility of felons to serve on school boards. While the precedent-setting decision could provide a path forward for others with felony convictions who want to run for boards of education, Adelson said it was more likely to muddy the issue further and invite future legal challenges. "I think it's still open for discussion as to who can hold school board office and who can't," he said. Part of the problem, Adelson said, lies with courts' reliance on a 55-year-old list that was previously repealed to define what constitutes an infamous crime today. The list does not include financial or cyber crimes or even something like attempted murder, but does include bigamy, which is seldom prosecuted. "I think the General Assembly is ultimately going to have to assess this and decide what are the crimes that if you commit you can be on a school board and what are the crimes that if you commit you cannot be," he said. "Because right now it's all over the board." Roger G. Pawa, the top vote-getter in Markham's mayoral election last year who has been prevented from taking office due to a 1999 felony mail fraud conviction, does not stand to benefit from the Barnett ruling, which applies strictly to school boards, his attorney Ross Seckler said. A.G. Pawa, who serves as fire chief in Country Club Hills and works as Markham's court administrator, will likely need the legislature to approve a change in election law for him to ever be seated as Markham's mayor, Seckler said. The Illinois Senate passed a bill last fall that would conditionally allow people convicted of felonies to hold elected municipal office or serve on school boards if they had completed their sentence more than 15 years prior to holding office, but the bill has stalled in the House. "We are hopeful that it may get revitalized," Seckler said of the bill, which has been stuck in the House Rules Committee since October. "It's been a bit of a roller coaster." KoskTribepub.com, Twitter @Zakos.